Here I am again in Lincoln's Inn basement, squirreling away in the stacks. Whilst I am here, I thought I'd talk to you about Lambe and Eames, which is Lambe and Eames 1871 6 Chancery Appeal cases at page 597. This is a very important case, not least, as Andrew and Martin have shown, in relation to precatory words. It turns the tide of the cases. In other words, it's a firming up of previous judgments that, instead of perhaps allowing precatory language, holds fast against that kind of deployment. What was that language? Well, it was this. The testator said in the instrument that the property was to be at her disposal in any way she may think best for the benefit of herself and family. Her, of course, was the wife of John Lambe, who was the testator, and the property, the subject matter, was a freehold house in Cockspur Street. So pursuant to the first will, that's to say John Lambe's will, property passes to her. But to what extent does that family element, so the best benefit of herself and family, mean that other potential beneficiaries can take that property? Why is this important? Well, she also makes a will, and in that will she makes provision for children, one of whom is a daughter, and indeed that is Elizabeth Eames of Lambe and Eames, and then Lambe is Henry Lambe, who is an illegitimate offspring of one of the sons, so one of Elizabeth's brothers. So the question is, before the court is, does an illegitimate son or grandson of the original testator fall within the definition of family pursuant to John Lambe's original disposition? And if, of course, he does, then he takes. Elizabeth Eames is unsuccessful in saying that he doesn't fall, an illegitimate son doesn't fall within that definition. Well, eventually it goes up to the Court of Appeal, as I've said, where we get some interesting language deployed by Lord Justice James and Lord Justice Mellish. And we see, for example, this turn of phrase from James: "I could not help feeling that the officious kindness of the Court of Chancery in interposing trusts, where in many cases the father of the family never meant to create trusts, must have been a very cruel kindness indeed." In other words, importing those forms of trust obligation is onerous. Was it in fact not just a gift to the wife, where she might make provision for family in due course if she feels that to be appropriate, or in fact is there some gift that is imbued or has attached to it some kind of instrument? Here, of course, we get the Court of Appeal saying no, there is no trust, property passes absolutely to the wife. So that's Lambe and Eames, a very important case, and one that you should mull on, incredibly short as well. So do have a look at it and see what you think.